Please call the case.
Good morning, Your Honors. The matter before the court this morning is the case entitled David Silverberg versus Brenda Kazanes, case number 22AP248 and 24AP056. Appellant David Silverberg is self-represented, and appellee Brenda Kazanes is self-represented and is appearing by phone.
Thanks very much, and good morning, everyone, again. Mr. Silverberg, can you hear me?
Yes, I can. Thank you, Your Honor.
And Ms. Kazanes, can you hear me as well? Ms. Kazanes? Are you there?
Looks like she's muted.
Can you unmute? Ms. Kazanes, are you there?
Hello? Thank you. I couldn't unmute myself. I can hear you. Yes. Thank you, Your Honor.
Okay, good. All right, and you both understand you've each got 5 minutes. Mr. Silverberg, we'll hear from you first. Please go ahead.
Thank you. Good morning, Your Honors. May it please the court. I am David Silverberg, the appellant and father of the children in this case, and I thank you for your time today. The family court has erred in an unprecedented manner of expanding parent-child contact while ignoring the clear evidence of harm and risk of harm to the children that has occurred throughout this case and at the time of both judgments. The court incorrectly applied the legislative policy on parent-child contact that makes exception for risk of harm, Title 15665A. In the cases of Weaver, Sundstrom, and in the proceedings under Judge Waples, the family court recognized and considered the harmful patterns of behavior around the children was not in their best interest of stability. Here, I believe the court's conclusions of the children's best interests are not supported by the contradicting evidence of harm and risk of harm. The children have suffered severe emotional harm during the 2021 proceedings that the parent coordinator documented as 8 months of emotional abuse and a relentless campaign to alienate the children from their father. Combined, the two older children have been hospitalized close to 100 days during the proceedings. They have suffered from severe mental health challenges and severe emotional disturbance. After Judge Waples left the court, the family court did not follow any of the recommendations given by the parent coordinator. The same harm to the children that was detailed in the parent coordinator's reports began to occur again when the court did not uphold those recommendations and alleviated the order for professional supervised visitation without it ever occurring. The family court in 2022 allowed the children to be further harmed when they were again kept and alienated from contact with me. They were dragged into the courthouse and pressured to testify. They were influenced to write letters to the court, and they were instigated to run away by violations of phone contact. The children's attorney filed an emergency motion at this time, stating it seems the current parent-child contact schedule is harming the children and that the children cannot make decisions in their own best interests. The family court clearly disregarded the harm occurring as represented by the children's attorney, the parent coordinator, and by the actions occurring before it. The appellee's brief and the court's judgments on appeal deny and disregard any harm occurring to the children, but the evidence does not support their positions, and the evidence clearly shows serious risk of harm during both judgments. In the 2024 opinion order, the court identifies the defendant's tacit behaviors that have acted with inappropriate authority over our child. But the court recognized the defendant's behavior. It did not comment, acknowledge, or consider the harm to the children by these behaviors. Since the 2022 final order, the defendant has continued to harm the children through covert violations of the court orders while complying with the alternating weekend contact schedule. The children have been harmed by direct undermining of my parenting and parental rights at every juncture, using alienating behaviors that position them against me. Secret meetings between our son and the defendant have regularly occurred outside of the contact schedule that had positioned him to lie to me each time. Last November, the defendant intentionally provoked aggression to our son by inviting him to travel with her during Thanksgiving, when knowing his holiday plans were with me. My decline to him sparked severe aggression against me, and directly after Thanksgiving, the defendant again met with our son in secret. Several hours after this meeting, he walked to the police station and cut his wrist in the parking lot with a knife. This is the harm that the parent coordinator had described around the children's reactional behavior occurring by contact and context with their mother. This case has never been about violations of parent-child contact, but has been centered on the emotional harm by the context of the parent-child relationship.
Mr. Silverberg, you have about 1 minute.
The violations of physical contact have solely been a result of the harm occurring to the children by manipulation. In 2023, the defendant had conspired with our daughter to run away from home on her 18th birthday in the same way the children were directed to run away several times before. The evidence shows the children have been severely harmed by the defendant's alcohol use for almost a decade and are still being exposed to her intoxication. The Vermont judiciary will set a new precedent today if it affirms these orders, a precedent that guides the family court to invite harm to children through alienation, by dragging kids into courthouses and having kids write letters to the court, as well as rewarding parents for harmful behaviors. I ask this court to reverse and remand these judgments and provide relief of a parent coordinator evaluation. Thank you for your time today, Your Honors.
Okay, thank you, and your time has expired. We'll hear from Ms. Kazanes now, please. Are you there?
Yes, Your Honor.
Please go ahead.
Thank you. I'm unfortunately not an attorney, so I don't really have that much prepared. Mr. Silverberg's discussion about harm to my children and the emotional harm done to them is there's no evidence that that is caused by me or my relationships with the children. They have been through severe emotional trauma through this separation and court proceedings over the last 4 years. The parent coordinator, as Judge Harris found after several hearings and almost a year of evidence, that the parent coordinator was very biased. She never spoke with me or the children much, but just to Mr. Silverberg. And her court findings are completely unfounded and completely biased. So I don't really think that that should even be considered in evidence of harm to my children. My children were taken from me at a status conference, a 5-minute status conference. And it was supposed to be for a few months, and it went on for years because of court proceedings being extended. And that was the real cause of harm to the children, is being separated from their mother. Sole primary caregiver. I was their primary caregiver their whole lives. The children wanted to go to court. I know they shouldn't even know about court, but they do. They know things, they hear things. They are, my son is 17 years old. My daughter's now 20, almost 20. So they do things, they make choices. And again, as Judge Harris had found through evidence, is that they made choices. They made choices to run away, to see me when we weren't able to. And that isn't something that I asked them to do or wanted them to do, put them in risk by running 8 miles down the road. But they were desperate. And things have been, aside from my son not going to school, things have been great, and the children aren't in harm. Everybody's having a 50-50 schedule, and everybody's happy with that. And things are going well. My daughter's doing great in school. She's in 1st grade. And they're happy. They're happy seeing both of us. And I just don't understand what Mr. Silverberg's intentions even are to keep the children from me. Wouldn't be good for anyone. That's all, Your Honor. Thank you.
Okay, thank you very much. Does the appellant have any time?
Appellant has no time remaining.
All right, thank you both. Please call the conclusion of the hearing.
The next hearing for the court will follow immediately.
Thanks very